Thanks,
Good
Mithali.
afternoon to everybody. Good afternoon to everybody, and for inviting me to speak to and try and answer whatever queries that you have. Abhyuday, I'll give it over to you to start the whole process.
Thank you, ma'am. So in the previous webinar, we had discussed some of the basic challenges, ground level challenges that were there in implementing the Act. Now we are going to take a closer look at some of the definitions. And the purpose of this webinar is going to be to facilitate basic compliance with the Act for the employers and to make them, for all organizations, and to make them understand, what kinds of situations women or their employees are protected in, and which kind of situations qualify as sexual harassment, which kind of situations do not qualify as sexual harassment. So this is the first time we have an exhaustive Act which is governing this issue. So interpretation of certain terms can be a little technical, and that's why we've got Dr. Kaul with us on this webinar. So let's move to the first part of this. So we are going to first understand what actually qualifies, who qualifies as an employee, because the Act is actually stated to protect employees at the workplace. The definition of employee is not literal. You don't have to be, and you don't have to sign an employment agreement necessarily to be an employee who is protected under the Act. So we are going to discuss this with Ranjana ma'am here. So an employee is a person who, the Act protects employees only from sexual harassment at the workplace. The question is, who's an employee? I have displayed the definition of an employee on the screen. We're going to move on. So maybe in the next 15-20 seconds, you can all go through this. And I'm going to now move on to certain practical situations. I will ask these questions to Ranjana ma'am, and she will be explaining the answers to us. So I hope everyone has got a brief understanding of this definition. They've been able to read this at least on the screen. So I'm taking a situation where one employee is working in a mall, okay, at one of the stores, and this person is harassed by an employee who works at another brand. Okay, so there are two different shops in a mall, and one of the employees working in one of the shops is harassed by another employee. Now, whom should this person explain to? Okay. Before I go into this, ma'am, do you think you would like to explain at the outline what an employee is? Do you want to explain?
Well, yes, I do, Abhyuday. First and foremost, this Act. Can you all hear me? Abhyuday,
yeah,
can you hear me?
Yes, your voice is audible.
Yeah. So now, first and foremost, this Act is for the purpose of prevention, prohibition, and redressal of women at workplace, not necessarily only an employee. So this is very important for all of you to understand that it is women at workplace. So this means that it could be a lady employee, and it could be a lady who has actually visited that workplace, which is the workplace of your company or your shop, as Abhyuday was pointing out. So if it is a lady employee who has been acted against by another male employee, or by any gentleman who might be visiting her workplace. That's one. The second scenario is a lady who is not an employee but has visited the workplace and is harassed in any manner or sexually harassed by a gentleman who is an employee in that workplace. So it is fairly wide. It is important to recognize this very, very fundamental pillar of this Act. Now, Abhyuday, you said an example of somebody working in a mall in a shop who is sexually harassed by somebody who works in another shop. Did you mean another shop or another branch of the same company which has the shop?
No, I mean another shop which is owned or leased out by another company altogether.
Altogether different.
Right.
So if the sexual harassment of this girl who works in this one particular shop has happened at her workplace, which is in the shop in which she works, then it is brought under this act. And in which case, what she will do is to immediately get in touch with the ICC of her or the local committee if it is a shop employing less than 10, and they will take cognizance of this, look at the fundamentals of what her complaint is, and then either hand it over to the police, because that is what is provided for under Section 509 IPC, or they will proceed under their own ICC guidelines if that person who came from the other shop is also employed by the same company running 2 shops. So this is how it will pan out. And of course, the other element is it a case that employees in shops are being provided by the person who owns and manages that mall? That, in other words, is this girl the employee of the mall rather than of a specific shop? So all these elements will have to be looked at, and above all, the harassment should have taken place in her workplace. If it's anywhere outside, it doesn't qualify.
Thank you, ma'am. So if we assume, let's assume that, yes, I'm here. So let's assume there's a McDonald's in that same mall, and these 2 employees meet in that McDonald's for lunch. One person is working for Adidas, and another person, I'm just giving a clarification, is working for another brand, Nike. And these 2 meet either, let's say, in the common premises of the mall near the lift, or let's say they meet at McDonald's during lunch hours. This is during office hours. So now, in this case, do we consider this to be sexual harassment at workplace?
Well, I mean, the point is that you said one works for Nike and the other works for Adidas, and all of this is happening in the McDonald's premises.
Right.
So it is not covered under this act.
Right.
McDonald's doesn't have to do anything about it except perhaps ask them to leave if they find it objectionable, whatever is happening.
Okay, so since it is during work hours, the woman has some sort of respite or not? She can just go to her own employer.
The point of the matter is that it is McDonald's, the premises where it is happening, that is McDonald's, is not to be governed by her workplace, because she works either for Nike or Adidas. So she may take it up with her own employers and say, this is what has happened to me. And if they want to check up, in the strict interpretation of this act, and they might say that, look, this place, McDonald's, was not your workplace, but the act also provides that if a lady has any such problem, lady meaning an employee or otherwise, then the employers can assist her in filing a complaint with the police if she so wishes.
All right.
But unless it's strictly happening within the workplace of that lady, who's the employee, it is not covered. But assistance is to be given.
All right. So the lady's own employer is required to give assistance in case she approaches him.
She wishes to, yeah, if she wishes.
Yeah. But since the premises, now the location of the harassment is very important, and this would not qualify as a workplace. What about what about working in a non-profit organization, on a salary basis?
It is covered. It says so.
Okay.
The definition of workplace clearly says so. Yeah.
Right. And even voluntary work we see is covered.
Everything.
So,
everything.
All right. So any person working, on a voluntary basis in a charity or in a non-profit, even these organizations would have to constitute, would be responsible for protecting their employees.
Yes, yes.
Great. So the first question has been answered. Second question is about off-site workers, because we just had a cursory, brush with the definition, with the meaning of workplace. So if if an employee is working off-site, could be at an exhibition, could be in a conference also, or they could be at a construction site. Would they be considered? Would they be protected from sexual harassment because they're not strictly working within office premises?
It doesn't say office premises.
Right.
It says related to her workplace.
Right.
It doesn't necessarily say office premises.
True.
And it also includes transportation that the company might provide.
All
You know,
right.
these charter taxis and such like facilities that are provided, and we've heard of many cases that have been very unfortunate.
Right.
Mm.
All right. And what about interns and trainees? Because there are many organizations which heavily rely on them, and interns.
Absolutely covered.
They are also covered.
Yes.
Okay. So every organization which crosses even 10 people, which includes the population of interns,
Yes.
even such organizations have to provide measures to protect these interns from sexual harassment.
You know, I want to lay emphasis on the fact that not only are women who are employees or connected with that entity in any which way, but even
Right.
a lady who is visiting the premises
Okay.
and is misbehaved with is covered.
Right. So should she go to the person who is responsible for work at the premises, or should she go to her own employer?
Well, she can go to her own employer, but where, now let's talk of, entity A. Now let's say that we are always talking about entity A. And this lady has come and a gentleman who is an employee of entity A has misbehaved. It is possible that other people don't know that this has happened. But certainly she will then go and should go to the ICC of her employer. And here's the thing, because the gentleman who has misbehaved is not part of her employer's establishment, that employer to whom the lady belongs will send the case directly to the police, as is provided in the Act. The ICC will recommend to the employer, I mean whoever is designated as the employer, to send the complaint to be registered under section 509 of IPC.
Okay.
Yeah.
And what about the possibility of, the other employer entertaining the complaint?
Well, there is absolutely, he is required to entertain the complaint, but it also says in the Act that this complaint process is to be governed by the service rules. So now
Right.
in this situation, the lady is subject to her own service rules of her company.
Right.
The gentleman is subject to his own, and there is no meeting ground. Now,
Okay.
so therefore, the lady is going to appeal or make a complaint to the ICC of her company. And her company's service rules do not govern the gentleman.
Right.
And in such a case, the law requires that the complaint is forwarded to the police.
Okay.
If the lady so wishes. At all time, this is not sort of a mandatory thing. If the lady so wishes, if she wishes to escalate it, then all possible assistance is to be provided for the purpose.
Okay. Thank you, ma'am, for outlining, the issue of traveling to work and, how to file a complaint in case the woman is visiting the premises of another employer.
Yes.
We'll discuss situations of traveling to the workplace again when we
Yes.
come to the definition of what a workplace is.
All right.
For now, the entire question of who is responsible for implementing the Act is quite important, because
Yes.
the Act imposes responsibility on the concept of an employer. Now,
Correct.
in the modern world, we have corporate bodies as employers. So, who is the person who is actually legally responsible for implementing this Act? For example, under labor legislation like factories law, you have the concept of an occupier who is responsible for ensuring compliance. Or under the Companies Act, you will have, you'll have an officer in default, or you will have a CEO or a CFO, or the board which is responsible. So under the Act now there is a specific definition. One part relates to government government departments, and the other part simply says any person responsible for management, supervision and control of the workplace. Who is this person? Is it the head? Is it the CEO? Are there multiple people? Can it be the HR? Can it be the board? Is there any clarity on this, ma'am?
Look, what we have to do is a harmonious construction of the various sections of this Act. So let's take a company under Companies Act. Now, essentially, we would say that ultimately the owners are shareholders, right? But that's not the extreme we're going to. But it is the board of directors. The board of directors, let's say in a company, are the employers. They will employ and they give appointment letters or whatever it is. Now, for the purpose of this act, because other than the fact that this employer is required to implement, so the board of directors would have to pass a resolution to say that we wish to implement this act in our company and that we will take necessary steps to formulate a policy and rules and so on, right? The next step is that when the ICC, the Internal Complaints Committee, is constituted, at the end of their deliberations, they have to produce a report of inquiry findings, and based on that report of findings, they have to make recommendations to the employer to do or not to do whatever it is that they have recommended. Now, obviously, for the sake of facility and convenience, it is not possible for the ICC to have a board meeting summoned every now and then if there is a complaint. So it makes sense just for a seamless implementation if a person or a group of senior persons are nominated by the board of directors to function as the employer for the purpose of this act. And so that the ICC, that group or that employer will become the point of reference for ICC.
And they
will be charged with the responsibility of implementing the recommendations of the ICC and doing all other things that are required under this act to do.
All right.
But you were saying something.
Yes, ma'am. So this is from one angle, this is from the view of viewpoint of administrative convenience, operational operational simplicity. What about from the side of legal validity? For example, for any kind of non-compliance. So the question is that for non-compliance, you have to pinpoint to the employer that the employer is responsible. Now, would this kind of a delegation of function work for this purpose?
No. So now, this is a very, very good question. So, for the purpose of carrying through the implementation in terms of ICC, you have nominated 2 or 3 people or one person to be the employer to carry out the functions under this act. But in the case of non-compliance or a breach of obligation, that would squarely lie on the table in front of the board because it is a company that is the employer. So we have to very carefully structure this, call it diarchy for the lack of a better word. And there has to be a seamless interaction between the two so that obviously at all times the responsibility should lie with the board of directors. They cannot absolve themselves of the ultimate responsibility. And you have, for administrative convenience, a way in which ICC always has access to a person or group of persons in context to this act and whatever problem might arise.
All right. So from the point of view of administrative simplicity, it is great to delegate this function completely, let's say, to an HR manager.
And remember that the Act does not prohibit that. Act does not prohibit that. It says that these things have to be complied with. That's it.
Correct. So ultimately, however, for non-compliance, the buck may not stop at this one person you have designated, but it will go back to the ultimate authority or the board of directors. Okay.
Yeah, absolutely.
Now the second tricky point, ma'am, is what kind of support, the employer has this responsibility for compliance. Now, when we look at it, there are 2 or 3 major things that an employer has to help out with. They have to create a sexual harassment policy, create a committee, and whatever annual reports are there, they have to be filed. But there is this entire gray area about how does the employer cooperate or facilitate the work of the ICC. Most employers think that we will notify an ICC, these are the members, and this is how, and if there is a case, please complain to the ICC. And the ICC is also sometimes relatively, does not have enough information on how to conduct proceedings, and the employer doesn't know how to facilitate it. Like with respect to all other operational aspects of the business, the employer will have a clear channel of communication. He will have a managerial style which will be used to actually, improve the effectiveness of the business. How does the employer in this case improve the effectiveness of the ICC? I'm asking this question because there is a specific legal responsibility under the Act, if I'm not mistaken, for the employer to facilitate the work of the ICC.
Yes, yes. All right. Now I'll tell you how it happens. Couple of things to remember. One, the onus and the responsibility to implement the Act is on the employer. In other words, he has to make sure that every single thing that is written in that Act is properly implemented. What does implementation mean? That the target audience is going to get the benefit of whatever that Act says. Now for that to happen, you have the ICC, which is that intermediary body which is going to help to disseminate all the benefits of this Act. In order for this to happen, the employer is obligated to provide necessary facilities. If you look at section 19D, right? Now what does this mean? Yes, you have to have a committee that has to be constituted by the board of directors. That committee to be called ICC, we all know that. But how does this function? This body is required to function in accordance to principles of natural justice. So for any of us who are familiar a little bit with law, you know what that means. It means personal hearing. It means the opportunity to represent and represent in writing. If you look at the rules, you will see that a complainant is required to give 6 copies of her complaint with a list of witnesses, their addresses, their names, and any other evidences. And also the ICC has the ability under the Act to summon witnesses that may have been listed by either the complainant. Now I'm saying complainant, although this word is not used in the Act, they call it aggrieved woman. And this is where you'll understand what I said, that the aggrieved woman could be an employee, a lady, or a lady who came to that particular workplace. It doesn't say aggrieved employee. All right?
Right.
So now the point is that how is this going to function? You need secretarial support. And my experience tells me that it is not a good idea to have the HR head or anybody in that HR department to be a member of the ICC. And why? Because the HR interacts very closely with employees. They know everything there is to know about these employees and whatever their problems may be. And we are humans, and sometimes it could result in a conflict of interest. All right? Okay. Very often I have heard this said that, no ma'am, but so-and-so doesn't like me, so she will not listen to me. These kinds of things should not impugn on the working of the ICC. So clearly the members of the ICC must be completely objective and sort of non-denominational, sort of individuals, right? But the ICC needs secretarial support that the HR can give. For example, there has to be a place where the complainant will go and give these complaints, the 6 sets of complaints. Who will receive that complaint? So it is a good idea for the employer to designate the HR as also the ICC office. And somebody should be tasked to receive the complaint, make sure that it is complete in all respects, because you cannot proceed unless a document is complete in all respects. Give a acknowledgement of having received that. Take that to the chairman of the ICC and say that, look, this is what we have received. What are your instructions? Summons have to be issued, files have to be made, other members have to be requested to come for a meeting that is scheduled. All of these things need secretarial support. And my suggestion would be always that the HR is best suited for this. They're also very accustomed to keeping files in order and, all of those things that are required for efficient working of the committee.
All right.
Yeah.
So let's do a quick recap only of this question, on the support. So there
Yes.
there is administrative support that the employer
Yes.
can provide through the HR,
Yes.
which includes maintenance of files, performance of necessary procedures,
Yes.
how the employer gets or the HR get knowledge of these procedures is another thing we can
Yes.
go and discuss. We
Yes.
can discuss that later about how
Yeah.
skill building must be done. But
Yeah.
it's essentially secretarial support, compliance with procedures, issuing necessary, letters, documents,
And also issuing summons.
issuing summons, okay.
Yes,
Preserving
issuing
files.
summons to the complainant and to the respondent or to the witnesses as the case may be.
So HR will need a lot of formats and
They will.
things
They
like
will.
that, right?
Yeah,
Right.
it's not easy, but once you get the hang of it, of course, everything is easy.
Right, right. Of course, and there are cloud-based toolboxes, for example, something that we have created for,
Yeah.
doing where all these templates are accessible online and, these
Yeah,
can be
yeah,
directly
yeah.
used by HR.
I mean,
All
for
right.
example, the company or the board will have to say, okay, fine, this is a venue that will ordinarily be used. It's a good thing to know where it
Right.
is that this meeting will happen. And remember that confidentiality is a cardinal pillar of this act. And therefore, wherever it is, I mean, obviously you can't sit around in the open somewhere in the middle of some place and have this kind of deliberation. It will have to be closed door.
Right.
Then it is a good idea to have a letterhead for the ICC because a summon has to be issued. So, I mean, you can do it on a plain sheet of paper, but a proper letterhead is a good idea. You could have
Right.
an email ID, for instance. There may be somebody who doesn't want to come up and say that, oh, I've got a problem, but may want to simply write an email which is dedicated only to the ICC members.
All right.
So those kinds of things, you have to deconstruct it and arrive at some practical solutions of how you'll make it work.
All right.
Yeah.
Thank you, ma'am, for that aspect.
Yeah.
What about, okay, I'll just check, we'll get to confidentiality also in more detail. Let's discuss it here only, in fact, what are the mechanisms that can be can be put in place to ensure confidentiality, and how do you what are the points of leakage? Because
points of leakage, yeah. Abhyudaya, are the people that are involved with listening to the complaint, receiving the complaint, disseminating the information. There is no other third person who can possibly know what is happening excepting for the complainant, for the respondent, for the ICC members and the secretarial support. If any one of them, and now we are talking of the obligation of the employer and the ICC, right, and people in the official capacity connected with this. So if right, they are the sorts who do not understand what confidentiality means or don't take that aspect seriously, and if for some reason it leaks out the information, the name of the person who's aggrieved, the name of the person against whom a complaint has been made, and it gets into public domain, by which now I mean the company surroundings, in any which way, there is a penal consequence that has been imposed in the Act. Okay. So we want to be extremely, extremely circumspect when dealing with these sorts of sensitive cases. Sometimes they're sensational in the context of a workplace, but they are extremely grave and serious. So they should be dealt with like that.
So there is a worry.
Look, you cannot stop the complainant from going and talking.
Correct.
But the respondent can complain against the complainant and say that, listen, she's made this whole thing public. Similarly, okay, a respondent might do that, and complainant can come and say that, this chap's gone and spoken to everybody that there is. And the use of social media in these days, uploading all sorts of, now that's a criminal offense, of course, not covered here, but covered under different acts, that.
That's true, but if they simply tweet about the incident, without uploading any obnoxious pictures.
But I tweet to you, and you tweet to 30 other people, and who go on to tweet to 90 more.
Yeah, exactly. So then it's very difficult to ensure confidentiality if either the complainant or the respondent themselves are participating.
You can't. That is right. But I'm just saying that there can be a complaint about it.
Right. My worry about confidentiality was slightly on a different aspect. So when a complaint is filed, an employee can request some kind of an interim measure. Now assume that there is a measure of transfer that is given. So let's say either the accused is asked to is put on transfer, or the woman who feels harassed is temporarily asked to work from home.
Yes.
In that case, at least there will be some kind of information given out on a need to know basis. For example, the seniors of the person, the team member, the team leaders of the person, of either the complainant or the respondent, right? They know the truth.
Abhyuday, the Act says those connected directly and indirectly.
Okay.
Are required to maintain, it's a fiduciary relationship. So they're expected to maintain a very high level of, this is what the Act says.
Internally, what should the organization do? Should it disclose the real reason for these kind of temporary measures, at least to the immediate team leaders?
No, well, I mean, your immediate boss would in any case get to know that there's a problem, right?
Right.
So
he can be put under an obligation of confidentiality in turn. That is fine, but he would have to be told the truth, right? As a practice.
I would imagine. I mean, that would be right. Yes.
Like you can't hold things confidential from him because you are working with him.
No, you can't. It's not practical. How can you call somebody who's manager of a particular department, say that what, we're deciding to transfer this guy, or we're telling him not to come to work for the next 15 days.
Right.
And of course you have to tell him. In fact, it has to be done in an extremely quiet, confidential and seamless manner, because you do not want to embarrass either the complainant or the respondent against whom as yet there has been no finding of guilt.
Correct.
Yes. A complaint doesn't mean that there is guilt.
True.
Yeah.
Let's look at what a workplace is. We just discussed it in brief earlier.
Yeah.
Now we'll go through the definition of the Act very quickly.
Yeah.
So I'll quickly change the screens. So the most important part is this: a private sector organization and a private sector undertaking, enterprise, trust, NGO, where different kinds of activity or services are being provided.
Yes.
Apart from that, certain specific workplaces such as hospitals and sports institutes are included. What's very important is clause 5 out here, which is talking about places visited by the employee during the course of employment.
Transportation.
An employer provided transportation. So this gets very murky on a few occasions. I have jotted down some questions, which make us fall, into tricky areas.
Okay.
The first situation we have already discussed, where an employee, the mall, and that's what is being asked here on screen. When an employee has visited a client site and gone to work in a company's office. So the employee who has been harassed, assume let's say there is either a lawyer or an accountant or a secretary, he has gone for some work at a client's office, faces sexual harassment, comes back, assume this lawyer assume this accountant is working with an accountant's firm. So this accountant was working with a CA firm, so they have to complain to their own employers, and since the place where the harassment occurred was not within the control of the CA firm because it's a client's office, the employer, or the best he can do is he can assist the employee to file a complaint under the Indian Penal Code, or he can also take some kind of contractual measures with his client. He can inform the client that this kind of behavior is not encouraged, and if this continues.
Abhyuday, the Act does not provide off the table
discussion. Okay.
It says that if the lady so wishes, then the employer is obligated to assist her in filing a complaint with the police.
That's all. Okay.
Yeah.
And
now that is actually a very tricky situation, as a matter of fact, for any employer who might have long-standing relationship of one sort or the other with another entity, and something like this happens. I mean, there'll have to be a test case in due course.
Okay.
I can't give you an answer for that. It's really, really difficult.
Okay. But when you are actually filing a complaint with the police, it becomes a personal matter. Like it would be the woman versus,
That is
you know,
why,
the woman
yeah,
against
so
the
that is
individual.
why it says that
Yeah.
if the
Yeah.
lady wishes and asks for
Yeah.
help, then
Right.
you
Right.
lead her and tell her that, look, this is where you have to go, this is what you have to do.
Right.
And then she's on her own.
So what I will, so one way to look at it is that, you know, both employers of the client
Yes.
as well as the
Yes.
employee who has been harassed, both of them can be
Yes.
hands off and say that, you know, whatever this employee committed, whatever action he committed was
Yeah.
completely outside the scope of his employment. It was in his private capacity and therefore he's facing a criminal action. So based on this argument, the commercial relationship and the goodwill can be preserved. Because, you know,
Well,
an employer
hopefully
is,
it will be
yeah.
preserved. I mean, but, you know, I mean, hopefully it can be preserved.
Okay. Now, since you said that off-the-table discussions are not permitted, now I think the same
Under this
answer will
act, I
fall.
said.
Yeah, yeah, they are not provided for under this act.
Yes.
So similarly, now employees who are at exhibitions or conferences, they also
Yes.
have no other recourse but to approach their employer who can provide assistance in filing a complaint.
Correct. Absolutely.
So one important question: where a person faces harassment in such situations, you know, now when you're in your own office, in your own company, there you are
Yes.
still likely to have the details of who is the person who has committed
Yes.
sexual harassment. You might
Yes.
also contact HR and get their permanent address and those details.
Yes.
So it's easier,
Yes.
you know, sort of to take up proceedings against them. But when
Yes.
this happens in a public place, I think there are some details, or at a client's office, I think it's important to have certain kinds of details so that you can actually lodge a valid FIR. Although the employer
Correct.
can assist, but if you've gone
Yes.
to a one-off conference and come back,
Yes.
it will be
Yes.
extremely difficult after that to procure details of who all attended, who was the specific person who indulged in that act of sexual harassment. So it's
Yes.
best if you have certain details. What could those details be? The name?
Well, those
Address.
details would be typically the name, the designation of the person, where the address where you're going to meet, how many people were there at the. Well, I mean,
Okay.
normally, isn't that what happens? I mean, you're going
Right.
for a meeting, you tell your secretary that, okay, I'm going to meet so-so, such, whatever, from so-and-so to so-and-so. I mean, those available.
No, but
I would encourage the younger and the junior employees also, who might be doing a lot more running around in these sort of, you know, meetings and so on, to know who they are meeting and how many people. But it is enough if
Right.
she's able to say that this is where I went, it was an official meeting, this was the purpose, this is the person I had to go and meet.
And the address of the person, because, you know, police will be required to visit that person.
Of course. Of course.
Right. So this is especially important for all the staff members who are involved in field work, off-site work, marketing activities.
So Abhyudaya, this is the reason why the Act obligates employers to run awareness workshops.
Right.
These very questions will become part of your training and awareness creation for your employees, so that they know what is to be expected of them.
Yes.
Right?
Right. So the next part is, one second. Again, this situation is, the first situation is covered. There is an interesting question of traveling to or away from office premises. Now, if it is employer provided,
employer provided transportation is covered.
To and from both.
Wherever that transportation is taking you.
Okay. So informal carpools that employees have themselves organized themselves into would not be covered.
That's their private lives.
That's their private lives, even if they're traveling to office.
But they're not, unless they're traveling in company provided transportation.
Right, right. No, if they are not, then it would not be covered. Because a lot of times employees get into these sort of personal arrangements. For example, in a law firm, you know, there is a partner who might just pick up his associate because they stay in the same area and, you know, travel to work and then drop him or her back. Now, in these situations...
Then in this situation, if she comes with a complaint to say, I mean, you know, she files a complaint per se because she's offended by something that happened.
Right.
Then I imagine that there would have to be a very serious look at the conduct of this senior person. If there is anything that suggests that this may be for a promotion, it may be for better prospect, whatever it is.
Okay.
But generally a employer must demand a very high degree of good conduct from their senior employees.
Okay.
It doesn't say so in the act, but this is what I would say.
Reason being because this was a very, very senior employee who was, sort of giving travel assistance to his junior teammate, and this kind of travel assistance could, in a case which went to a court, it could qualify as transport being provided by an employer.
No,
or,
no,
it wouldn't.
not at all.
But because the promotion would clearly fall within, the linkage of
it is because the relationship between this very senior gentleman and the girl is such that he is in a very dominating position.
Okay.
Maybe she's not able to refuse taking that lift. Maybe she's going there willingly. And it is not always the case that a complaint means guilt.
Right.
It also does not mean that a complaint doesn't mean guilt. And more often than not, it could be consensual, which goes sour, which goes bad, and then there are consequences. So all of these factors come into play. And it is a good idea really to also have a counseling session for senior people, and also in any case, but also chiefly because of this act, to say that, we need to be mindful of all of these things, especially when we hold very senior positions, or a position, even if not senior position, you're a manager or you're a associate and you have a younger, let's say a lawyer working for you, an intern for example, it is expected of you to behave yourself, right?
Right.
Yeah.
So, okay. Now what if in today's professional life, people are expected to travel a lot with their teams. So an entire team might just travel for a client, for work with a client off-site. Now that could be a week-long travel. They will not have a standard work day which is 10 to 6. They will be with their professional team. Their work day may be extended, but there will be a time when the work day closes. However, there are going to be like team dinners. There are going to be in the normal course of events also, team members are likely to have dinners together. They will be traveling together to the airport and back. So would these so any instance of sexual harassment in these situations would be covered within the contours of workplace? Would it be said to have occurred at the workplace?
Look, now here they are traveling to work, right? So they're going to somebody else's, some other client's site for work-related travel.
True.
Right? But while some part of the day, as you said, is in that client's premises or wherever related to work,
right?
We are not expecting that there will be any such incident involving colleagues, sexual harassment in somebody else's premises is not normally what I have encountered. But what could happen is because of the amount of time people spend with each other, after the day is done and you have your free time, some situations might evolve or happen that might trigger a complaint. Now that is happening in their free time. It will impact the company naturally, because if she brings a complaint to her company and says this colleague of mine, this is what happened, then while strictly it is not workplace, under the act it is not workplace, right? But I imagine again this is going to be test case. Again, what should the ICC tell this young lady? That I'm sorry, it's not covered by workplace and you're on your own. That's not good HR, isn't it?
Right.
That's not good HR. So maybe then rather than ICC, the HR can deal with the complaint. I don't know.
Oh, okay.
One will have to think it through. One will have to think this through. What happens right now in a company, before the act, before the ICC, when there is a problem like this, they go to HR?
Right.
And HR then takes it up with whoever it is that they wish to take it up with.
Right.
And more often than not, some sort of a settlement or whatever it is happens, and one of the two might leave or not leave, as the case may be. So let us
Right.
not pull things that are not strictly covered by the Act under the ambit of the Act. Let us not read more into the Act than what it says it is. But simply because you have ICC doesn't mean that that parallel apparatus which is being operated by the HR should be closed.
Okay. Okay.
Because these kinds of situations, she will go to HR. Ordinarily, she'd go to HR and say, no, this is what's happening.
So typically organizations, yeah, that's true. So
You know,
typically
so,
organizations, sorry to interrupt me.
No, carry on.
So, okay, what I've seen is that organizations have a code of conduct where they have, they specify, what kind of behavior is expected in any interaction, unless
Yeah.
it's a consensual relationship, of course.
Yes.
Then in
Yes.
any interaction, what is the level of conduct expected? But yes, since the Act has come into place, sexual harassment has been completely moved out into the sexual harassment policies, and it
Yes.
only covers sexual harassment as per the definitions of the Act. So
Correct.
what you have made here is a very interesting suggestion that,
Yeah.
for implementing best practices for
Yes.
human resource development and personnel, I think it may be advisable, you're saying, to have some kind of, to have another mechanism in place, the existing one. where
No,
HR
yeah,
can-
the existing. Just carry on with the existing mechanism.
True. So sexual harassment that way at workplace gets so sexual harassment gets addressed in two ways. Under the Act, it is as per the committee, and just some borderline cases where the employer wants to give protection as a matter of good HR
No,
practice.
no,
we
no,
can have
no,
some-
no, 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 no. Abhyudaya,
Not like that.
where sexual harassment by one to the other is happening at the workplace,
Right.
which means that both parties are engaged in their working time, whatever that working time may be, will
Right.
have to go to ICC. But you're saying that if they went out of town and later on at the end of the day's work, they're sitting and they're having dinner, having wine, whatever it may be, and then there is
Right.
an incident, then what happens?
Right.
I'm saying that then in that case, it needs to go to HR first
Right.
to ascertain the pegs of when it happened and where it happened. And then
Okay.
if by the yardstick of workplace it fits, then it will have to come to ICC. Because this is a gray area, isn't it? I mean, unless we test these propositions with actual things happening and people bringing complaints, it's very difficult to give a definitive solution. But
Right.
this is what, on the top of my head, is what I would say would have to happen.
All right. This is very interesting. It's quite nuanced.
Yeah, it is. It is very nuanced.
So another example, this is something that has been asked time and again.
Yeah.
What about sexual harassment in parking lots of the building, okay, or just outside, the office gate? These are, I
Not
don't know, is there
workplace.
like a not workplace?
Not workplace.
Okay.
Not workplace.
Parking lot?
But not workplace.
Okay.
I mean, is the parking lot, does it belong to that company, or it's a place hired by the company to park company cars?
So
You
in
have
any,
to look at all
Yeah,
of that.
right.
You'll have to examine all of that. And in any case, an aggrieved lady will want some place where she can go and say this.
right.
Then maybe she can go and tell HR what happened.
But not ICC because this is not workplace.
Not ICC, because if
Because
it
she's
is,
going
let
to work,
HR
she will
determine.
Right.
No, let HR determine whether, what do you mean by parking lot? It could be some dark shady corner that belongs to nobody. And it could be a
Okay.
company
Typical, let's
rented
take a-
parking slot
Yeah. Yes.
where the guy who's doing whatever he's doing has parked his car, or two people unconnected with the car that belongs to an employee in the office are
Right.
over there. Then you'd have to ask, why are they over there? All of
Okay.
that.
Shall we, let's make a very simple ramification of the situation.
Yeah.
For example, one being where there is in any office building, for example, even
Yeah.
let's say Tolstoy House, where
Yeah.
Dua office is situated. One of the
Yeah.
floors is belonging to Dua, 2 floors are belonging to Dua, and therefore they have a few parking
Slots.
they have few parking slots. So if a
Yeah.
company has such dedicated parking and one of the owners of these vehicles,
Yes.
harasses an employee who is nearby,
Yes.
in that case, would we
It would,
consider it
I
to be
would
workplace?
imagine it will get covered because that parking slot is dedicated to the company. That parking slot is
Right.
dedicated to the
That was the
company. The
question.
company
That's right.
pays the rent for it,
True.
or has purchased it, as the case may be.
Okay. Understood.
Yeah. Yeah.
And the next situation about voluntary rides, we have just discussed. You have explained how senior
Yeah.
management should pay. The conduct of senior management is very important from a company perspective also.
Yeah.
And how, sometimes employees may not be able to refuse such
Yeah, that's right.
such offers. True.
Yeah.
And now this is something interesting. We just discussed what happens if an entire team has gone outside and post
Yes.
work they are just having a personal dinner. Now there are certain events which are dedicatedly considered to be team dinners which happen outside, which happen post work, but all team members will congregate, they will celebrate, let's say
Yeah.
the closing of a transaction, they will celebrate a deal. So what are these? Are these work related events?
They are work-related events. After all, they're closing a transaction. And they won't
They
all
are.
be there if it hadn't been for that transaction.
Right.
Yeah.
Okay, just 1 second. So we can move. This is a short conclusion. Okay, we have summed up, what happens if an employee is going to all these borderline areas where either there is another employer in control of the workplace or
Yeah.
the employee is completely off-site, where in a public
Yeah.
place, for example. So what
Public
happens?
place? How do you mean public place?
Public place or in a conference or, doing market research on ground.
Yeah.
In these situations, what can happen? We have summed this up. So,
Well, you would have to identify who is it that the complaint is being made against.
yeah, that is true. So
Yeah,
you helped
then
us.
that-
You helped us with the guidelines that
Yeah.
there are certain details an employee must always have. If they are thinking of
Yes.
reporting about sexual harassment, they need to have certain details because otherwise, how do you
Yes.
call the person? How do you
Exactly.
investigate into the
Exactly.
event?
Yeah. Absolutely.
Okay. Now the most critical question: what is sexual harassment?
What is
So-
sexual harassment?
Now we have a
Well-
definition under the Act,
Yes.
but
And
there
and
are
you
certain,
also have
yeah,
and you also have in section 3 subsection 2 circumstances,
indicators.
some
Right.
circumstances that also constitute sexual
displayed on
harassment.
screen now. Are we referring to
Yeah,
these
that's
situations?
right. That's right. That is section 3 subsection 2. So
Yes.
you have to read your section 2 subsection 9, which is the definition, which says sexual
Which is
harassment
this.
includes, right? And
Physical
you will
contact,
read it
right.
together. You will read it together harmoniously with section 3 subsection 2, which says that the following circumstances, among other circumstances, that means not limited to this.
Right.
The following circumstances, among other circumstances, if they occur or are present in relation to or connected with, and they list out 5 of them.
Got it. So this is basically certain actions, physical contact, gestures, sexually covered remarks, innuendos,
Yeah.
showing
Yeah.
pornography.
See,
Now the thing is,
essentially, Abhyudaya, the thing is this. You look at the definition in 2N. It says sexual harassment includes any one or more. So what they're
Right.
doing is that they are giving flexibility to the ICC to
right.
evaluate the facts that are presented to them by the complainant
Right.
and take an objective evaluation, arrive at an objective evaluation of whether in fact this could be said to constitute sexual harassment.
True. But what is the use of these situations about, promises of preferential treatment? The reason I'm asking this is because these have to coexist with a sexual with another act which is clearly sexual harassment. Otherwise, any treatment of preference, any promise of preferential treatment with it in itself is not sexual harassment. On an isolated basis, one cannot say that this would amount to sexual harassment. But yes, if it is present, a gray situation where an employee doesn't know, is this a demand for a favor, is this a demand for a sexual favor, it would be clearer, if that demand is accompanied with a preferential treatment promise, then it would be very clear that, oh, this person is looking for a sexual favor.
Life doesn't always go in straight lines.
True.
Now there can be a situation where she's told that, okay, fine, you do this for me and this is what I'll do for you. But on the other hand, it could be just, being extremely nice and friendly for the longest possible time and then leading on to other things. Now, you could have a situation where the complainant, if there's a complaint, actually does not quite understand the nuances of it, is really actually very simple, and ends up in a situation which otherwise she would not have. And at the same time, you can have somebody who understands perfectly well what this is going to lead to and goes along with it. Like I said, very often there are consensual situations. Then when things fall apart, well, then they fall apart really badly.
Right. Okay, so I understood. Where there is, there might be situations which you just can't interpret, whether these are sexual harassment instances or not. But looking back, sometimes, when they clearly turn sour and you see that there was a promise of a promotion,
yes,
or some kind of threat about adverse consequences, then you know that, okay, this is now sexual harassment, and that's how you complain to the ICC. And this is a point for the ICC to,
the ICC will, no, it is the ICC, that is the reason why you must always ask for, and the law expects you to get a written complaint. She must commit to, we can sit and say many things. But when you commit that to writing, you may not include all the 30 things you said. You might just say that, oh, actually, let me just put these 10 because this I know I can substantiate.
Right.
You also have to see whether you can provide evidences or you can have witnesses. All these things matter. That is the reason why members of ICC should be mature, objective people who must look at it dispassionately. We are not for anyone or against anybody. We must look at it dispassionately and say, does it fall squarely within the four corners of what the Act provides?
Right.
Then proceed.
So now on the meaning of sexual harassment, we had some questions. What should women in organizations which have less than 10 employees or 10 women, there could be two versions of this question.
How should women in organizations which have less than 10 women?
It should be 10 employees. 10 employees. Organizations which have less than 10 employees, how should they report sexual harassment cases?
Well, the law provides a committee is going to be constituted in every district. The district collector will constitute a local committee, and such a complaint is to be filed with the local committee.
Okay.
For less than 10. For less than 10.
Have these committees been notified? Has there been any notification?
No, in fact, as a matter of fact, I was trying to get in touch with DC in my area, and I was not able to get him on phone. But to my knowledge, as yet not. But subject to correction. Yeah.
Okay. Also, the next question then. So, one second. So, in this case, if there is no ICC, there is no requirement to constitute an ICC, but an employer can still constitute an ICC if they wish to.
Of course, there's nothing prohibiting you.
Yes. And but in the absence of a local complaints committee, where should they go? And there is no ICC.
I just told you. If they go to the court, then
they go to the court.
Yeah. Go under IPC, I suppose.
Under the criminal law, not under this act.
No, because you don't have that ICC.
Okay.
Because you got less than 10.
Okay. The other question was, can sexual harassment be more widely defined by an organization than it is under the Act? Nobody wants to complicate the definition.
Look, I'll tell you what. The Act provides you what is the minimum requirement under law.
Okay.
if you wish to expand and better it, because you know your organization best, you have the historical background of what are the things that have happened or not happened, and you would like to cover it all. Well, there's
Right.
nothing to stop you. But what is given in the Act must be covered.
Right.
It's not an either or, but it is an and situation.
True. So even male employees can be covered in
Yes.
cases the employer wants to.
Yeah.
Okay, excellent. We'll have a detailed webinar on how to cover male employees. You know, the last webinar in this series.
Yes.
is
In
going to
fact,
be how
I've
to
been
make
asked these questions several times by a variety of people I'm advising.
True. So there will be an entire model that will be discussed as to how operationally it will work
Absolutely.
in
Yes,
case you
yes,
protect male
yes.
employees.
Absolutely.
Another tricky question: can a woman file complaint against another woman under the Act? You know, sexual harassment.
Not under the Act, because the Act provides for a respondent who happens to
So
be
the
a
respondent
male
is a-
employee. You
Only.
look at the definition in section 2M.
Okay.
Who's a male employee or any other employee who's not an employee, any other male who's not an employee, but is alleged to have subjected a lady employee to sexual harassment at a workplace. So presently, respondent does not include another woman.
Okay.
So there lies your answer. But yes,
So-
you can expand the scope if you wish to expand the scope of ICC
Right.
and say that, look, we want to cover it all.
Makes sense. Okay.
Yeah.
There was this question, I think, ma'am, we had already discussed this, and this is a
Yes.
very tricky question. So imagine, you know, a lot of times people are used to quick decision making, summary action. Okay, so there's a senior manager who's observed something and he thinks this is sexual harassment, and he wants to
Yes.
take punitive action. You know, simply he wants to
Yes.
punish the person who has been involved in this conduct. He wants
Yes.
to either withdraw his perks, or withhold a promotion, reprimand or rebuke the person, or
Yeah.
simply fire him. So imagine
Yeah.
a situation where the company or the senior company management has come to know about an incident where there is no written complaint from the woman
Yes.
yet. Okay.
Yes.
So and he has taken some action.
Yes.
So first question is, now it's on screen. You know, can an action be taken if a written complaint is not filed? This is the first question.
No, because unless there's a complaint, the ICC can't view a complaint. We're talking of ICC has to do all these things. Now,
Right.
if you have a manager who has observed and he thinks that, the best thing is to have this person leave, then I'm presuming that he's going to take the matter up with his seniors, get their concurrence, and only then move to do what he's doing.
Right.
But such a situation is not covered in the sense that the Act does not contemplate this. So therefore, I would say no. Unless there is a complaint, how can ICC take cognizance?
All right. And what about a decision? So there can be no cognizance taken. Now assume, let's assume that the woman has reported to the senior manager, and he has been an eyewitness, and he thinks he's the boss in that setting,
Yes.
and he also has the powers to hire and fire under the company, under the company structure.
Yes.
So he decides that this is sexual harassment, and he wants to fire without taking any recourse to the ICC procedure.
No,
You
he
think it
can't
will
do
be
that. No, he cannot do that, because a senior manager, he knows that the company has implemented this policy and that there is a ICC in place, and therefore it would be his responsibility to counsel
Right.
the lady in question and say that he plans to have a meeting with ICC. He wants to have her there present so that they are seized of the matter, and then the best course of action can therefore be determined. He get an ICC in the case of a complaint of this nature.
So
Especially where the
circumventing-
lady has complaint. You
Yes,
cannot
yes.
circumvent the Act and say, look, she came to me, she didn't go to ICC, so I want to fire her.
You can't say that you're complying with the law by instituting
How
this
can you say
alternative.
that? How
Right.
can you say that? The officers of the ICC have not been used. The recommendation for sacking that person must go from the ICC. That's one of the measures that ICC is empowered to recommend.
Okay, so let's assume in a situation that this has happened. Now, what kind of risk is faced by the company, or this has happened due to whatever lack of knowledge or awareness of the senior management. So can the company or the senior management personally be held responsible for this? And in what will be the kind of risk they face?
I don't have the facts and circumstances, so difficult to say. But
So
if
assume
this
they have
has
made
happened, no,
yes.
let's say that it has happened. There was no written complaint found out.
No, I'll say there is a
written
written complaint. There was a written complaint to the manager, not the ICC.
All right. But is there an ICC at the point in time when this event happened?
There is.
Then there will be a problem. Then there will be a problem if somebody were to complain about it and say that this is what has happened. And that complaint could very well go to the local committee as and when it is notified to say that, look, this is the organization I work with, this is what has happened, and they circumvented ICC. You don't really want to go that route.
So there is danger. So what kind of risk can we face? Like, employers can be asked to pay compensation for wrongful termination or any wrongful measure.
I mean, one will have to look at it. If there is a complaint, so this is speculative.
Worst case, yeah, it has to be speculative because, we don't know of a live case like this.
But we don't know of a live case like this. Yeah.
So on a speculative basis.
I'll tell you what it is. You're saying that the lady complained to a manager in writing.
Yes.
The manager then proceeded to take swift action and have the gentleman leave the company.
Yes.
I am presuming the lady is satisfied with this?
I don't know. Yeah.
I mean, I don't know. Right? So maybe it is not she who's going to complain to the
person who is removed might complain.
Exactly. So, I mean, it may have happened, as you're saying it has happened, but that would be skating on thin ice.
Okay.
I would not recommend companies to circumvent ICC if an ICC in fact exists in their company.
And if it doesn't, they are still required to create one. So I do not see any possibility of using.
Yeah.
Right. This can only happen maybe in an organization with less than 10 employees.
This can only happen where there's less than 10 employees. Yeah.
Then it is still okay.
But it could happen.
Yeah.
Look, I mean, the point is this, that if somebody wishes to complain, whether she's working in a place that has less than 10 employees or more than 10 employees, and she's determined that she's going to complain, well, she will complain. You might take as an employer whatever circumlocutory procedures that you wish to take. But that doesn't mean that the person who is determined to get justice or to bring somebody to book is going to let it go.
Right.
Yeah.
So like in the US, we have an entire category of employment malpractice litigation, and employers take a specific kind of insurance just for this kind of litigation, that if we wrongly fire an employee and the court holds us responsible to pay compensation, the insurance company will pay us all the costs that we incur in defending ourselves, assuming we as employers have been innocent. If we are at fault, then even the insurer will not help. But if we have been innocent, we have spent money on our lawyers, we have incurred legal costs and other necessary court fees and costs, so then we will be recompensated by the insurer. So that risk exists even in India.
Well, now with the implementation of the Act, and as time goes back and we will see test cases coming up, then this whole corpus of torts will develop and criminal law will develop.
All right.
Yeah.
So,
wrongful dismissal or whatever.
All right. We'll discuss the question on the ICC in another session where we are just focusing on the ICC. The question was, now we had already discussed that no action can be taken if a written complaint is not filed. Now there is a flip side to it. If there is a woman who informs the ICC about an instance of who informs her senior and says, I don't want to file a complaint.
Yes.
Okay. Now no action can be taken, as you said. What kind of support?
The point is that when she goes and meets ICC and says that, look, this is what happened, but I do not wish to file a complaint.
Okay.
Then the law requires for the ICC to ask her what the difficulty is in filing that complaint. If she is not able to, for whatever reason, doesn't know how to, whatever be those reasons, then a person must be nominated by the chairperson to say that you will assist her in writing this complaint. There could be a lady who is not able to because of physical infirmity, mental infirmity, or such like, all those are provided for. But if she simply says that, oh, this is what's happened and I'm not going to write a complaint, then it becomes very difficult. Then it really is a catch-22.
Yeah.
Because, and I'll tell you why, because unless and until you actually record what she's saying by way of complaint, then transcribe it, because I might say that I went to Khan Market yesterday, and then I might say that, well, I haven't been there for 1 week, and
yes.
You're going to say to me that what you just yesterday you were saying you were there last evening.
Okay.
So it's very difficult. So you will then have to you have to find your solutions. Either you record the whole thing,
so
then you say, okay, now these things, this is what you said, now do you want us to proceed with this matter?
Okay.
We will have to inform the person against whom it's no use complaining and then not complaining. Do you know what I'm saying?
Yes, yes.
Yes. So those kinds of situations, I think in any case many HRs must have dealt with.
Right.
Yeah. So that is why it says that a written complaint will be given, and if there is problem in that lady being able to write it or frame it properly, then assistance must be given. But
okay.
As you know, you're a lawyer, so it is hearsay. It's hearsay.
Yes.
Or sometimes if there are situations which seem, that so-and-so said so-and-so to me, so what should I do? Then you can offer solutions and say, look, talk to the chap, so whatever it might be. Or if you want, we can call him over here and you can sit down over here and talk to each other, sort it out. The usual, those. But then you are conducting yourself in a HR mode, right? What you would otherwise do. But you're not conducting yourself strictly under the Act.
Okay.
You would handle it the same way, as HR would.
And even this was the same case if the report has gone to the manager and not the ICC. If the complaint has gone to the manager.
If the complaint has gone to manager, he is required to send that because it's in writing. He is required to send that complaint to ICC and tell her that I cannot deal with this at my level. It has to go to ICC because that is what the mechanism in the company now is. Yeah.
All right.
If it's a verbal complaint to the manager, he can ask her, would you like to go and see the ICC and talk to them about it? Or do you want to go to HR and just talk it over and see what can happen? You know what I mean?
Yeah. And now this is the most tricky question, I think. Should organizations encourage or discourage consensual relationships, whether sexual or any kind of romantic?
Should organizations encourage or discourage?
Should have a stand,
What do you mean, Abhyuday? I never heard of anything like this before. How can organizations, what do you mean?
I'll give you an example.
Give me an example.
So in any workplace, most organizations will not have may not have a policy. There will be a neutral policy.
Yeah.
People might engage in a romantic relationship. Okay.
Yes.
Some organizations, on the other hand, have a very clear policy against this.
Yes.
Okay. And despite any organization having or not having a policy, automatically there are people who are in some kind of consensual. There are people who enter into some kind of consensual relationship, whether sexual or not, that is not our concern. But sexual harassment can follow when the relationship has turned sour, or other forms of harassment may follow also. So is there some kind of a safe stance that you want to suggest?
Yes, I think it might not be a bad idea to look at best practices of some companies that, certainly in the Western world, they have this. Where they seriously frown upon any kind of relationship between co-workers in an organization.
Okay.
There are places like that. But that doesn't stop it happening in any case, right?
True. And another question on whether organizational culture impacts what instances are treated to be as sexual harassment. So there might be a conservative organizational stand, or there might be areas where, in the creative industry, sometimes, you're in the course of work only coming out with very, very creative ideas. So sometimes they just end up being suggestive maybe, or, you might have a more libertarian view of things. So are these notions
No,
permitted,
see,
or you know?
no, listen, you cannot control a person's mind whether you're working in an extraordinarily conservative or not a conservative, right?
True.
That is not the intention of the act.
Mm-hmm.
The intention of the act is that the woman in question must not be harassed, sexually harassed at her workplace.
Right.
Now you have a creative unit, an ad agency, which is doing this, that, and the other, whatever it is, fine. That's part of their work, ordinary business.
Mm-hmm.
That doesn't mean it's sexual harassment.
Right.
Yeah.
And so basically the committee needs to understand sort of understand the context in which people are interacting, whether
Of
people
course.
are taking it in the right sense or not. You know, sometimes
Look,
there
Abhidya,
are jokes.
I'll also say that you should not focus only on the top employees. You have a vast amount of administrative staff in every company.
Yes, yes.
They come from a universe which is somewhat different than those in managerial positions.
True.
Starting from management trainees upward, they're different people. They come
True.
from different backgrounds. Their state of evolution, for the lack of, I don't mean to be looking down upon, somewhat different. Their sensitivities are different. So you
Yes.
have to be able to factor all this in. As
Okay.
I think when we were talking the first time you came, when we were
Mhm.
talking about a particular entity that has offices all over the country, and they did a survey, I suggested that, why don't you do a survey about this awareness and say that how would you like to have it conducted? Where would you, and North India, the Delhi people, particularly Chandigarh, Delhi and all that, they said, no, we want it separate for men and women. I'm talking of the administrative stuff. And
Right.
south of the Vindhyas, they said, but what is the problem? It is the same for everybody. Will sit together and we listen. There are
Right.
cultural differences, and it is good for an employer to be a little bit, not brush it away simply because you don't subscribe to that, but know that people live differently, they think differently. That is what will
Okay.
make a company's effort successful.
All right.
Yeah.
So we are moving more or less towards the last few questions.
Yeah.
Sometimes there is, you'll see when a consensual relationship has gone sour within the workplace,
Yeah.
there might be some forms of discrimination or, detrimental treatment, unhappy, sour treatment that a woman may receive from her seniors.
Yes.
I'm giving a typical context. There could be different situations.
Yeah.
Now, would this kind of conduct qualify as sexual harassment?
Yes, absolutely. Absolutely. If she
How
files a
so?
complaint, it is covered by the Act.
But at the time there was a sexual relationship, there was no harassment.
No. When there's a consensual relationship, there's a consensual relationship, right?
True.
And then it goes sour and this so and so forth happens. There have been
But
many
then
cases.
there is no sexual reference or no sexual innuendo, no part of the definition of sexual harassment is satisfied.
It can be a case, a good lawyer would build a case, not that lawyers are allowed to appear before ICC, but a good lawyer would build a case to say that this whole premise of sexual relationship was premised on a dominant position. And it was premised that if I went along, and therefore it became consensual in due course, if I went along, that I would be treated preferentially. Now you would say that if you were defending the opposite party, you would say, well, I mean, if you knew all these things, why did you agree? Why didn't you stand up to your principles and say, well, I'm resigning? But that's easier said than done.
Okay.
So all circumstances will have to be looked at. After all, it is not just the woman's side that ICC must appreciate. The respondent has something to say about it. That is what natural justice is. And at the end of it all, they might reach the conclusion that actually there is nothing in this that needs to be recommended and the case needs to be closed.
Okay.
Where both are contributory.
Mm-hmm.
So that is the reason for the inquiry.
And okay, that's good, ma'am. What about what is the typical way to address misconduct that does not qualify as sexual harassment? Have you seen organizations dealing with this before, until this act had come into picture? Usually they have a code of conduct or some kind of mechanism.
Yeah, you have to have a code of conduct. You have to have a code of conduct. But now that this is in place, again, we're back to the same thing. There has to be a complainant and there has to be a complaint to ICC. Then the circumstances
Right.
will be taken into consideration.
Right.
Yeah.
In case of a gray area, where of course, employees are not supposed to be knowing the intricacies of what is sexual harassment and what is not. So in case of a gray
No, but
area,
that is
they
what
should
you
be
will
encouraged
do,
to
isn't
complain.
it? No, but you will conduct workshops for them, right?
Yes, yes,
You will
of course.
conduct workshops.
But the specific reason for which the ICC is constituted is to find out the facts and then make a determination as to whether something
Yeah.
was sexual harassment.
Yeah.
An
I mean,
employee
you're
will-
asking me about sometimes things that are said, where there was some gentleman who asked during the course of a training कि अगर मैडम अगर मैं किसी को कहूँ कि hello dear, how are you, तो फिर क्या वो sexual harassment होएगा? Now it all depends on who's listening to that and to whom you're saying it and how she might interpret. And yes,
Yeah.
she could interpret it as sexual harassment, and then in that case it would be. Do you know what I'm saying?
then the committee, of
So
course, has to
your
decide.
your
Yeah,
awareness training programs have to be extremely well thought out.
The quality of
And
training
the
is very important.
and the Q&A that follows must not be only for the matter of form, but actually with adequate time, because people are reticent to talk about this in the first place.
Right.
You need to make them feel comfortable to be able to ask questions.
Right.
Yeah.
Ma'am, are you aware of any sexual harassment law compliance under shops and establishment laws?
And not to my knowledge, no.
You're not aware of any of that? Okay.
No.
Because sometimes
no.
I think companies we have not done, I have not looked into it at the moment, but there are companies which have been asked, by a shops and establishment inspector.
No, no, they will be asked because all laws have to now get seamless with this act.
Okay.
And in any case, the definition of employer covers even those entities such as NGOs and so on that are governed by shops and establishment. So it's automatic. Yeah.
But and person who's in charge of enforcing the Shops and Establishment Act, he wouldn't have any powers to check. The Labor Department wouldn't have.
Well, I mean, he could if he wished to, but although at the present point in time, and Shops and Establishment Act is state legislation.
Yeah.
It's state
Every
subject.
state will have different.
Every state has it. So they should bring in that amendment to say that,
last part, we've almost completed this.
Yeah.
We have addressed this. This will be available in the PPT that we share. So any participants who want to read this can later on access this PPT.
Yeah.
Okay, the last question was, what can be done if the employer is involved in that harassment?
You have to file with the local committee straight away.
Or the
ICC. No, not the ICC. When the complaint comes to ICC to say that, let's say the managing director is doing this.
Right.
That ICC will have to have a written complaint about it all. But the recommendation to the employer, whoever is nominated by the board,
yes,
is to send it to the LCC, Local Complaints Committee. Yeah.
Okay. Also, we were referring to section 509 of the IPC, which is about outraging modesty and now the thing is that there has been an amendment where the same definition of sexual harassment as is under the 2013 Act, the same definition has been placed under the ICC. Sorry. So
I mean, of course, you're looking at the amended definition, of course.
Of sexual harassment, yes. Yep. Now the question is, in which situation should the ICC, encourage someone to go to the police, and in which situation should it take it upon itself? Is it based on the seriousness or the level of evidence available?
Of course, no. Look, you arrive at seriousness. You say that the situation is serious after you have appreciated all the facts, the evidences, the witnesses, and taken time to deliberate upon it and said, this is what our conclusion is, and it is serious.
Okay.
And only then a recommendation will be made, isn't it? To the to follow through as to whatever it is that has to happen.
Right.
Yeah.
Okay, ma'am, there are a couple of questions that we have received.
Yeah.
1 second. One is display of constitution of internal committee of the complaints committee mandatory at a sales office where there is no female employee.
No, say that again.
So there are certain offices where there are no female employees, no women employees. In that case,
including the administrative staff, everybody.
Including everyone. There are no female
Every single
employees.
person, and there's not a single woman.
There's not a single woman. Or a situation where there are less than 10 employees and there may be women, but there are less than 10 employees totally. So the question is, should the constitution of the committee, the notice about the committee be displayed?
I think it doesn't make sense because there is nobody to cover under the Act. But if there is an inquiry or an inspection, then you would have to give a statement to say that we do not have any. This is the list of our employees. We do not have any women employees. As such, there is no. We are not covered under the Act.
Right. I'll just narrate a couple of questions. There are a lot of them. We will answer some of them offline.
Yeah.
So there's somebody who's 1 second. So I think a clarification is needed about the HR's participation in the internal complaints committee. Is there a legal prohibition to that or not?
No, there is no legal prohibition to that. It is just my suggestion with my many years of experience in with the commission and so on, that there could arise. You don't want a situation where either the complainant, your entire effort of the inquiry is vitiated because the complainant or the respondent says that there is conflict of interest over here. And so I can never have an unbiased. Yeah.
So HR should try to play safe instead, and
so HR can be necessarily, if they're giving secretarial support, you can have an ex officio secretary. Right? You have an ex officio secretary who will be there present at the time, but whose only job is to make notes and all that sort of thing.
Right.
Take instructions, follow through all those things, but not participate as a member. This is my suggestion.
Right.
Yeah.
Another question, this is the last one we'll be taking and the others will be taken offline, ma'am, is there should be a senior level employee who is the president of the ICC. Now, the Act does not define any level of seniority, so what should be considered to be
whatever in a company, whoever is seen as being a senior person, it doesn't mean anything, but obviously not somebody who's just got 2 years of experience or something. What they're looking really for is somebody who's mature, who's seen it a little bit, knows how things play out, and is therefore a little bit more objective on these matters.
All right.
That is what they mean by senior.
All right, ma'am. Thank you so much for your insights. There are some more questions which we will either forward it to you, or we will take it offline. Right. So at the end, before handing over to Mithali, I just wanted to point out that in case any of our participants are interested in actually exploring a cloud-based compliance mechanism, Ranjana ma'am, for example, pointed out the importance of sensitization for employees and the kind of training that is required even for the committee members to be able to effectively perform their duties and discharge their responsibilities. So there's a cloud-based training program that we have built. And in case anyone is interested, they can visit our website or send an email to us. And I'll hand this over to you, Mithali. Thanks, Mithali, for having us on this webinar, and over to you.